I don't know whether you are very comfortable as a judiciary with the quality of justice you are dispensing. I have been addressing myself to, I think, Article 126 of the Constitution. You as the judiciary, are you comfortable with the quality of justice you are dispensing? Do you think the people of Uganda are happy with the way you are dispensing justice? Really? You may, I don't want you to look at me as this member of parliament, but anybody coming to you to seek justice in the courts of law, is he happy? And I'll give you an example. A very, very, if you look at the figures of people on remand, it is inexcusable for a person who is seeking justice, and who is seeking justice, the complainant. He was the victim of crime. And 15 years, 20 years, that case, that complaint has not been disposed of. A victim of crime. And the advantage I have is my first job was actually a prosecutor in the DPP's office. That was my first job. That you were a state attorney, you get a file, and you start looking for witnesses who witnessed a crime 15 years ago. I mean, you people, you just don't know the injustice you do to people. Because 15 years ago, somebody has grown, his beard is now older, and then he said, do you know the accused? The witness says, no. Have you ever seen? Said, no. Because 15 years is a long time. And you know, you see, when an offense is committed, the witness doesn't have to have observed that incident for maybe hours. It could have been for only minutes. Seeing an accused for only minutes, and now you present this particular accused 15 years later, and you expect a prosecutor to have a successful prosecution. What a job. So, I want you to realize, as the judiciary, that there is a problem, and we must handle it. Some of us who have been your allies, I have been here for a short time, only 24 years. Yes, only 24 years in this house. I want to be a little bit longer. So, we now lose morale. You are saying you were demoralized, you are not being paid well. There is nothing humanly possible we did to do for you to be paid well. We did. And you must be happy as a judicial officer. You cannot complain. I'm sure you know that when the Judicial Service Commission is now advertising, people are even coming from Kenya, they want Ugandan judicial service jobs. It's a true story. Even, yeah, that sort of thing. You get it? So, as far as morale, you have no excuse at all about emolument. We have done what it takes to make you people comfortable as far as emolument is concerned. 2, numbers. Every other time we increase the numbers. Even now we've just given them, we gave them the other day, so many judges. Even at the lower level we are doing the same. But what is the problem? Backlog, what is the problem? The average time to conclude a case is certainly way above a reasonable time. And the country cannot continue like this. Please. You need to come, go back to your chambers and say the people of Uganda are not happy. There are very few people who are happy with the way you people are dispensing justice. And I think it is so good. For those who have appeared in this committee, you know, this is the first time I speak like this. Because it's not excusable. For example, Mr. Jeremiah, do you know, there is this simplest thing called bail. Bail. and somebody adjourns the case for 2 weeks to grant bail. This is madness. This is purely madness. It is not professional. It's not legal. It's not common sense. It's not. Take a decision whether you grant or not. Simple. The only thing you can do is, okay, let's look at it the following day. But you had done for 2 weeks to consider bail, or even more. What are we doing, gentlemen? And some of you, we call you lordships, we call you worships. Actually, the some we have baptized them and names they are going to be buried with. We call it justice. Why are you justice when you cannot dispense justice? I think this message should be clear that this is how the people of Uganda are feeling. Don't be lied to yourselves. Judgment or notice. I think we now need to ban this by law. Take this message, we want to ban this by law. Litigants have got a right to know when you are going to deliver their judgment. You can't say judgment on a notice. You know what judgment on notice means? Or when I feel like, when I wish. A judge should be able to adjourn a case to a particular day for judgment. It creates a certainty for the litigants. It creates certainty for the advocates, knowing very well their judgment will be on a particular day. If that day the judgment is not ready, they come and you explain. Say, look here, I'm sorry, the judgment can't be ready. You come back on this particular day. But you cannot just say judgment or notice, and you sit for 6 months, 1 year without a judgment. And you say, I am justice. I'm Justice Katuntu. You've taken a whole year to deliver judgment. Just imagine the uncertainty you are causing to the litigants. Because what the litigants do, they eventually go to the lawyers. Then the lawyers, with all these unesco things, maybe the judge wants this, maybe the clerk wants this. Now they start troubling clerks. Can you people there? You know, what is happening? You know, because of that, there are so many unesco things that come on. Because there is that uncertainty. Why is the judge not delivering it, or a magistrate not delivering a judgment? Nobody knows. And lawyers are very uncomfortable to write, because you may take it up to them to write and inquire when you are delivering a judgment. The judge will say, well, if you want, I give it to you. And you know what you can do with that. So I think, Mr. Vigirimana, this message and the acting chief registrar should go clear that the public is not happy with your judgment or notice, and this is part of the backlog. Lastly, I could have spoken more and more because there are few. I have been in that place for quite a number of years, longer than I've been here. Bar-bench relationship. I don't think the lawyers are happy with this relationship, the way it is going. The ordinary lawyers. At some senior level, especially you people holding these two positions, secretary and then the chief registrar, you need to have a way of sorting out this. It doesn't look good in the eyes of the public. Let's diagnose the problem. Where is it? What has caused this relation to deteriorate to this level, such that we seem like there is a war between the bar and the judiciary? What is it? Can't the leadership of the judiciary, because the leadership of the judiciary has an advantage, their leadership is a little bit permanent. The leadership of the bar has its own problems because it is in and out, in and out. So you must, maybe if you are having a problem with the leadership of the bar, you must find a way of resolving it through either leadership of the profession to engage the leadership of the bar, and then the leadership of the bench to resolve this. Because it's not good. Obviously, sometimes the language itself is not like, when I was in the law school, I was never trained to use that sort of language. But these days, those who are born later than us, maybe it is all those who went to law school later. So, I think you two officers, you need to find a way of trying to sort out this. Because it's not good for our profession, it's not good for the sector. You must find a way of resolving it. It means, by the way, I don't have any solution. I don't know how you're going to do it, but you have to. How you are going to do it, that is your business, but you have to, because you have that responsibility. Is it going to be very easy? No. That I also know. It's not going to be very easy at all. But you must work on it and resolve that relationship challenge, resolve the impasse, engaging whoever you should engage, and we move forward as a sector. Mr. Chairman, I thank you. Sorry, I could have been a little bit longer, but I thought it was necessary.
Thank you. I'll have Honorable Seth next. Are you ready? But before you come in, colleagues, ladies and
the first question relates to the quality of justice and personnel. You go to one judge, get this judgment, the following day you get another one, the precedent is different, in some cases even when the law is very clear. Personnel. One day I met the principal judge back then. I will not mention which principal judge. And I said, oh, where did you deploy so and so? I said, he's there, that one. Oh. But you know you don't allow me to fire, so I can't fire him. And I said, yeah, but you could deploy such people in places like judicial training. He said, oh, he goes and trains them how to do that. You know, then you get some of the best. You move them from the stations where we need them. Need them meaning they are the engines of that particular court or station. And he says, so and so is taken to Judicial Training Institute, is taken to inspection, and so on and so forth. Administration, basically. Most competent, most senior, diligent at work. How you deploy, and now this is about deployment. You get very senior judges. You deploy them to places that have literally no work. This explains part of the backlog. Again, part of the backlog, I think Honorable Odur and Honorable Katuntu mentioned something. At some point, Chief Justice Benjamin Odoki asked a question. You adjourn a bail application. What is so novel in a bail ruling? More so sometimes in a magistrate's court. Someone tells you, I'm going to hear your case, but I'll hear your bail application 2 weeks, 3 weeks away from today. You are defeating the Constitution. Because in the Constitution, everybody is entitled to be free, except where the accuser places on your table justification for restriction. Isn't that the position of the law? Every innocent person is entitled to freedom. Now, you're aiding the state to incarcerate somebody who is innocent until 2 weeks when that person will come to justify his freedom. I think it's unfair. So apart from the Constitution, you also, encroaching on the budget, because prison has a budget. And that's why they keep coming here to ask for supplementary. We budgeted for 70,000 remand prisoners. We've got 180. Honorable Odur talked about it a bit, especially these political prisoners. You get somebody who is battered, who is bleeding, and you remand that person. You do not even instruct prisons, go and keep this person from hospital. Instead of, you say, I'm remanding somebody to Luzira. You know, just next door in Kenya, Kenyans went and burnt their parliament. We do not want to see Ugandans burning our courts. Why? Because once the dignity of the court is questioned and shaken, we are in trouble. Because somebody would have taken me to court will use a panga. Will resort to mob justice. Why I'm very passionate about bail is I have enjoyed bail for the last 16 years. Me, I'm on bail for 16 years. My daughter, who was not born, is 16 years. And when I go back to that court, they tell me, we cannot find the file. So I'm not discharged. I'm on bail, which is not extended. I'm waiting for an opportunity for court to cancel my bail and call me, or probably order for my arrest. I go and say, okay, finally my file is here. So we refer to you sometimes as colleagues. Honorable Katuntu said you are our lords. Our lords. Be lords. Be worships in all respects. The question of bail refund, why should it be so complicated? I remember somebody in my village said, you can try to pursue this bail refund for me. First, it was little money. It was a lot of money to that old person, and I could not defy. This is somebody who saw me grow. When I pursued and I decided to give up and get the money and give it to him. Bail refund is a problem. Why don't you streamline? Bail monies. Why do you charge a lot of money? Somebody has been arrested. Actually, somebody is a victim. The police arrest people, beat them up. We witnessed it in Kawempe recently. Someone has been boxed by the DPC. He comes to you with a swollen face. You remand him. Then when you choose to hear, you ask a lot of money, for a lot of money. These ordinary people, they pick on the streets trying to survive. Why do you make bail so prohibitive? We have guidelines on bail, by the way. I'm happy. But are they followed? Do you have a system that periodically reviews the decisions of these judicial officers? I would want to be one of them. I would want to aspire. And you know, for me, I'm talking about the judiciary carefully, consciously and cautiously, because it is my food basket. Okay? But I'm not suffering myself. If I'm suffering, would you want?
We should start thinking about going away from the guidelines and make a substantive legislation which sort of ties your hands. It is very unfortunate because we want a judicial officer to have the discretion to exercise it judiciously. But if like is faced with a fait accompli purely by the law, then so don't make the legislature go to that level because somehow you are not exercising that discretion properly.
Unfortunately, if you did that, I'll take you to court. And they will rule that it is unconstitutional because you have tampered with their discretion. You can now see. Somebody said, I will help you cross the river. He said, but there's no river. Said, I will bring one. Now, and we are speaking this because we want our systems to improve. So the quality of personnel. At some point, I had a matter where I raised an objection
And the judicial officer said, okay, ruling on notice. It took him 4 years to give me a ruling. 4 years on a preliminary objection, which I raised orally in 30 minutes. And when he gave me the ruling, guess what? It was 4 pages. So a colleague of mine cracked a joke and said, so he would write 1 page per year. I agree. We want to protect your discretion. We need it. And we do not want to do anything that destroys a small portion of the judiciary, because we run to you when we are in trouble, when we have put ourselves on fire. But we do not want to get to that level. Finally, somebody talked about promotions. We see very many senior judges and their staff. Are you saying they are not competent? If they are not competent, is there a mechanism that determines the competence or otherwise, so that you fire them? If they are not competent to be promoted to the next level, and you bring junior people to go up there and review their judgments, then fire them. It means they're eating our money for free. But you must have a mechanism that assesses. A lawyer is told, you file a defense within 15 days. The judicial officer will tell you, file your submissions by this date, and I will do that. And there is a sanction if I don't. Where is the sanction to the judicial officer who fails, who does not honor on delivering judgment on time or in time?
Blame game. The director CID and the whole team in charge of investigation, and then the prosecution. And my question is, and I may be wrong because I've had some judicial officers are here. When you sit in that judicial chair, do you sit as a neutral person without feeling some sympathy or empathy for the prosecution against the accused person? That, oh, now because the CID, they have not done their work well, or because the prosecutors have said investigations are not complete, I am therefore inclined to agree with them. And my question, I would assume, people who have practiced at senior level here, if the accused person comes to you and keeps telling you, I'm not ready to proceed with my defense, then after 2 weeks, he comes and says, I'm not ready to proceed with my defense. 3 times, what do you do? So why do you give a favor to the prosecution, who is also one party before you, to have the liberty to keep informing you, the judicial officers, we are not ready, we are not ready, we are not ready, and you adjourn remand. But when it comes to the other party now, who is also before you on the same weighing scale, and I think I saw somewhere here, this logo of the judiciary, maybe I've misconceived it. It's like a weighing scale. You come, you are at the same level. So why is it that now when the process starts, you tilt it to favor one side? Would you be comfortable to do that? I want to know, because there are so many. And I think even you appreciate, you can say very bogus and stupid cases that are brought on the face of it, and then it is entertained for 2, 3, 4 years. My thinking and my understanding was that you are an independent arbiter. You don't have to have any other consideration for the rest. You deal with things that are before you. That's the reason why we have, I think, more than 80 out of the 80,000 people in prisons. I think half, or about 50,000, are people on remand. And we recently established some have taken us as long as 20 plus years. So my question is, because I have not been there, what happens if a judicial officer sits after 2 or 3 or this number of months and said, I have released the accused person on bail because the investigations have delayed and this. Is there any threat that comes in the night? Or you feel you cannot sleep if you do that? Because I want to understand. Is there something that happens really seriously at night, or you are surrounded? There is what threat is there if you do your work as envisaged in the Constitution? And this has, I believe, in my opinion, has dragged the judiciary, and you have your reputation as the integrity of the judiciary is going that line. That people are losing trust because they think you have also become kind of accomplice or to enhance this persecution. So I would like to be addressed on that. The third issue is whether you have a mechanism within the judiciary to inform your clients that you are not able to proceed. Here in Parliament, although sometimes it happens late, when we are coming for a sitting, we are informed that maybe the sitting has been adjourned or is not taking place. So many lawyers are driving from here, Kampala, to go to, say, Mbarara, or to Mbale, or to Lira. And only reaching Lira, you are told the judicial officer is not available. Can't you have a mechanism of informing your clients that barring emergencies, leave alone accidents and etc., maybe the floods in Kampala last time I saw, many of you could not reach court, etc. But these are happening so frequently and people are wasting a lot of resources. You have spoken about the economic value. You know how much fuel someone will waste time and etc. to go to up country, and then all of a sudden you find that court cannot proceed. So can you develop a simple mechanism to inform your clients in time so that we don't lose all this time? The other issue that I have captured is in your planning for election petitions, 300 election petitions for the financial year, and your costed work plan in Q1 you'll handle 75. Q2, you will also handle 75. So I wanted to know which election petitions are you going to handle between July and September, and even September to October, the first 2 quarters. It is in your work plan. Is it just a matter of feeling that the template, because we expect this to happen from January, at least second quarter onwards, but in your own costed work plan here, we already see that you plan to handle 75, just spread across all the quarters to make the 300. And then at Court of Appeal, of course, you say 80. I don't know whether this 80 is informed by the percentage of appeals that you know out of 300 you are going to get 80. What if all the 300 turns out into an appeal? Then what happens now to the budget allocation if you have planned only for 80? The fourth issue I want to know, and this I will require some breakdown. The High Court circuits, how much money do you send to each? And why are some circuits having more judges, and yet it appears the cases are not even many than others? Others, you overload one judge at the station, the cases are so many apart from the backlog and the cases that are coming, and then you find in some other areas, even up country, you have like 2 or 3, and where people require justice, you don't seem to post judicial officers there. So one of the things I keep hearing when I go in seeking justice in court is that there is no money for the judges to do their work. I don't know what kind of money required. So can you give us a breakdown of each High Court circuit and how much money is going to be sent to those circuits to be able to dispense justice? Then I will not add more, I think, to what the Deputy Chair raised. There are so many budget lines, donations, we've seen ex gratia payments, we have pensions, we have gratuity, but I've seen ex gratia. and I'm sure you know the concerns that were raised first from here within Parliament about those ex gratia payments, service award and etc. What particular payments are falling under this ex gratia outside the pensions and gratuity and the ones provided in the as benefits in the administration of the judiciary? The other one is the Judicial Training Institute. I've seen you have trained 210 judicial officers in human rights. I would like to see the list of the judicial officers trained on human and what aspects of human rights were they trained on. Because from out what we see, there seem to be probably very low regard for human rights amongst judicial officers. People who are tortured are brought before you. You don't even recognize that. People who are sick are brought before you. You remand them further. People who are also this all human rights, people who are frail and you see they have not been eaten, and for you are just pleased. So, what aspects of human rights are judicial officers trained on? Are there other special types of rights that we don't know that you find comfort in? On the staffing, I do not really have the list, but there seem to be a number of judicial officers that are either stuck at a certain level or even at some same station. No promotions. Every year, here, Judge so-and-so is still here, Judge so-and-so is still here. And others come, and when in the public they seem to be, even when you speak to stakeholders, even fellow judicial officers, speak to lawyers, speak to clients, they seem to be happy. Even the rate of disposal, but they are stuck there. No promotions. Others are privileged to only serve in some areas. They never move out of certain areas. Others are, yet they are supposed to dispense justice all over the country. So what is the consideration for some of these? I don't want to mention names, but I'm sure many of you, I don't know whether it's the registrar, might know some of these officers who are, but other senior colleagues can add when they know them. A few might come. And lastly, where a judicial officer, and this has nothing to do with the independence of a judicial officer and the questions around their decisions, but where it is clear that a judicial officer has abused the authority, like it was pointed out in that, I think one of the cases where one of the justices at the Supreme Court found out where there is that blatant abuse outside, you know, maybe deciding a case this way or that way, but you can see that there is clear and obvious abuse of authority to persecute or to perpetuate. For example, a judicial officer sits without hearing even the parties, makes an order, makes a decision, convicts, all these things. It has happened. What are you doing about those particular ones, particular cases? Those particular cases that seem to be even fast-tracked. There are so many other files from 1990, 2000, but there are these ones that come, and within just 2 weeks or 1 month, there is already a decision. Those particular issues that are making the judiciary look very, yes, someone has said shabby. What are you doing particularly about those? And judicial officers who sit and start quarreling on things that are not even before them in their judgment. They're quarreling about things that are completely not even before them, but they are quarreling and commenting things that are picked from, I don't know from where, things that are picked from outside, and you find them there. What are you going to do particularly on that matter to ensure that the integrity of the judiciary is restored? Now, it doesn't spare us, even us here in Parliament. There are questions around us, but for us, we go for elections. So the disciplinary mechanism is there. We are disciplined during elections. But for your case, it's different. Thank you, Chair.
Thank you.
There seems to be a growing discontent in your number one clients, which is the bar, in the relationship between the bar and the judiciary. We do not want to mingle into the nitty-gritties of the procedures and processes of prosecution, but there is a growing trend by the judiciary. I don't want to use the word persecution, but I will borrow it from the public. A growing trend of the judiciary persecuting their own number one clients, which is the bar, the lawyers appearing. I personally appeared before many judicial officers. Some of them are even here. I've appeared before His Worship John Paul a number of times, and I have not had a problem. But the bar is the first clientele for the judiciary, and there should be a very cordial relationship between the two. What is happening, Madam Chief Registrar? Why is there growing discontent in the relationship between the two? Yet these are supposed to enjoy a collegial relationship, being members of the same profession. Is there a side which is not paying attention to the desires of the other? I really want to understand this, and we need to create a solution to this problem. Thank you, Chair.
Interact with the CJ.
Some of the shortcomings that have been experienced, and some of them are systemic, others are for individuals in the judiciary. We do apologize. But we are not just seated. We are looking at all those areas that have got weaknesses and see how to fix them, both in the human resource, both in the systems, as I'm going to tell you.